Hi, my name is Tommy Swate. I'm both an attorney and a physician. This afternoon, I would like to discuss with you the fundamental legal aspects of taking the USMLE. Now, I know that you thought that you wouldn't get involved in legalities until you got out of medical school. Wrong. The USMLE is a trap for the unwary. And I really hope that you're listening to this videotape prior to the time that you sign up to take either Step 1, Step 2, or Step 3. When you sign up to take the examination, you make an agreement with the USMLE, National Board of Medical Examiners, that you will do certain things. One of the most important things that they have you agree to is that you won't disclose the contents of the exam or undertake any other activity that might affect the validity of your score. It's really important to know what the definition of irregular behavior is as defined by the USMLE, National Board of Medical Examiners. I'm going to read the definition that comes out of the brochure that you will sign. Irregular behavior includes any action by applicants, examinees, potential applicants, or others when solicited by an applicant or examinee that could compromise the validity, integrity, or security of the USMLE exam process. If they, and by they I mean the USMLE, National Board of Medical Examiners, find that you have engaged in irregular behavior as defined by their definition of irregular behavior, a note will go on your transcript that states that you engaged in irregular behavior. This note will go out to licensing boards, residency programs, or any other entity at which you request the scores be reported. It will be like a scarlet letter around your neck. It's very important to avoid being charged with irregular behavior. The problem is the definition is so scattered that almost any activity that you undertake can be labeled irregular behavior. That is, they can investigate it as irregular behavior. For example, not stopping when they tell you to stop the test immediately, writing on tissue paper a question, or any writing other than on the material that they supply you. Talking to others, asking others about what's on the test, inquiring on the internet what's on the test. It goes on and on and on. Of course, the question I have is, until you sign the agreement to take the test, you're not bound by their contract. And I always wondered what would happen if someone inquired about the test prior to signing up and making a contract with them to take the test. But I do not recommend you take that risk. That is not what I'm recommending. You want to review their brochure very, very carefully. They will list multitudes of actions that can be considered irregular behavior. Please review those prior to taking the test, because you do not want to have to defend yourself for irregular behavior. Now, if you're charged with irregular behavior, it is not hopeless. Many people can defend themselves from the charges of irregular behavior, but in order to do so, you need to hire a lawyer who is both competent in medicine and law to defend you. I read all the time about that people out claiming that they're the world's authority on the national boards, and the foremost authority in the United States. I just laugh, because most of them who are making these claims don't know the difference between an otoscope and an anoscope. And I don't think that that's what you want defending you. My name is Tommy Swate. I can be reached at 713-377-4860. If you have any questions, please feel free to call me. There will not be a charge for me to talk with you about whatever concern you may have. In fact, I specifically suggest if you have a concern, don't let the sun set on it. Let's talk about it together, and if there's a problem, let's see if we can resolve the problem. Again, my name is Tommy Swate. I can be reached 713-377-4860.